the date and time that was originally set for sentencing. I have received and reviewed the recommendation from probation with Ms. Johnson. She has not, we do acknowledge she has not completed the alcohol screening and assessment through Von Schwartz, and she did miss a test on July 1st.
Please state your name for the record. Right away, we're in court, formal and tense. The defendant gives her name, Ms. Johnson. Small moment, big stakes. This is the moment the judge and everyone in the room anchor to the case. You can feel how official the scene is. Quick question for you. Does hearing a name read in court make the situation feel more real?
I did discuss this with her yesterday on the phone and advised her to go to community corrections as soon as possible to try to test. She informed me, and so did her father, who is here with her today, that she did go to community corrections this morning before court and was there for about 45 minutes, and they said she was unable to test this morning. We are respectfully requesting that the court not remand her at this time and that we adjourn the sentencing out in August to give her the opportunity to complete the alcohol screening and assessment. She is gainfully employed at St. Joe's. She does not want to lose that job. In the alternate, if the court is inclined to remand her in both speaking with Ms. Johnson and her father, our request would be to potentially allow that remand to happen a couple weeks in the future so she can.
The defense starts by saying she's reviewed probation's recommendation and admits Ms. Johnson hasn't completed the alcohol screening and missed a test on July 1st. This is a key admission. The defense isn't hiding problems. They're asking for mercy. Notice the subtle attempt to frame the miss as an oversight, not defiance. Who do you think benefits from that framing? The defendant or her lawyer?
Take time off work at St. Joe's so she does not lose that job. Other than that, Your Honor, we respectfully request an adjournment of the sentencing.
And Teresa Clare on behalf of probation. Your Honor, I did communicate with community corrections this morning. She did go over, and she wasn't scheduled to do a test today, so she did not test. She did do her download of her scram. I just confirmed with them that there was no violations on the scram. However, she had not reported to them after.
Her lawyer explains Ms. Johnson went to community corrections that morning but couldn't test. They asked the court not to remand her and to adjourn sentencing to August so she can keep her job at St. Joe's. That's a classic trade-off. Accountability versus stability. The plea is human. Don't take her job, but the judge will balance fairness and precedent. Would you prioritize keeping a job over immediate punishment?
June 15th. So there was quite a bit of info that they had to download on that. So I do know that there was no violations on the scram. However, probation also wants to point out to the court that this court did direct her back on April 3rd, I believe, and warned her about any further mistesting. So she was given a warning by this court back in April about her remaining compliant with the testing order.
Probation pipes up. She wasn't scheduled to test, did a scram download with no violations, but hadn't reported since June 15th. This complicates the defense's "it was an honest effort" story. The scram being clean helps, but not reporting raises compliance flags. Tone shift here, from plea to procedural facts. Which side carries more weight for you, the clean monitor or the missed check-ins?
Why?
Why what?
Why'd you miss a test? I mean, I gave you a huge break back in April and just told you, just don't miss the test. You remember that, right?
Yeah.
And then when you pled, why didn't you do your alcohol screening and assessment?
Forgot to print it out.
What?
I said I forgot to print it out.
The judge recalls April 3rd, a prior warning. The court's patience is on record. This is dramatic because warnings increase the consequences of future misses. The judge's voice here is the heavy metronome of the courtroom. One more slip, and the penalty escalates. It's a reminder that leniency has limits. Do you think past warnings should make judges harsher or give defendants one more chance?
Oh.
Oh. They do so much. I mean, I didn't send you the last time.
Then comes the direct, emotional back and forth. The judge asks why she missed the test. Ms. Johnson says she forgot to print it out. The response, the judge's visible frustration, drives the drama. Forgot sounds flimsy next to the court's instructions. This is the moment the narrative shifts from paperwork to responsibility. Is "I forgot" acceptable in a legal setting where lives and jobs are on the line?
I'll re-refer to defendant to Von Swartz for completion of her alcohol screening and assessment. Young lady, understand something. If you don't do it, and I don't have that alcohol screening and assessment, the only thing that I can really sentence you to is the maximum time. And I don't want
The
to.
paper,
What?
the paper,
What
with all
paper?
the lists on it. What is Von Schwartz?
That's for your alcohol screening and assessment.
Is there somebody I'm supposed to go to? What does that name stand for?
We get clarity. Von Schwartz, the assessment provider, is explained. The clerk and defense sent the packet, and there's a $75 referral fee Ms. Johnson hasn't paid. The judge stresses that without the assessment, sentencing options narrow, possibly to the maximum. That's cold reality. Administrative details can change outcomes. Small fees, big consequences. Ever been surprised how a little form or fee changed something for you?
That's somebody that you need to call to set up an appointment so that they can interview you and do an assessment.
Okay.
And Your Honor, my office, I know that the clerk's office sends things out. My office also sent an email to her on June 5th, which gave her the packet and the information for the alcohol assessment in addition to the information to complete the victim's impact.
Need to pay a $75 referral fee. Do you have that?
No.
Adjourn her sentence at August 28, 2000.
The judge warns she might find Ms. Johnson in contempt and sends her to jail, but instead orders 3 days for a bond violation. The tension peaks, momentary relief mixed with punishment. Then her father, Tony Johnson, steps in, pleading to help, offering money, promising to make sure she completes the requirements. The human side returns: family, support, shame, urgency. It's an emotional pivot from courtroom rules to real-life consequences. Would you feel comforted or worried seeing a family member step in like that?
2024, 9 a.m. Young lady, you are leaving me with no options. And I have a feeling that if you don't follow this, that I'm going to end up sending you for the maximum time. I don't want to do that. I'm going to end up finding you in contempt and sending you. So in this, I'm going to, for the bond violation, I'm going to remand her for 3 days. Washtenaw County Jail for the bond violation. Defendant's remanded.
Summary: Ms. Johnson failed to fully comply with ordered assessments and missed testing windows despite warnings, April 3rd and later. Defense asked for an adjournment to preserve her employment. Probation noted lapses in reporting. Outcome: the court imposed a short remand, 3 days, on a bond violation and instructed the family and defendant on next steps: Von Schwartz assessment, fee payment, Scram downloads. Broader implications: this case shows how administrative compliance, forms, fees, scheduling, can pivot a case from leniency to incarceration, a cautionary tale about procedural diligence in criminal supervision, call to action, CTA. Final VO. If this clip grabbed you, hit like, share, and subscribe for more courtroom breakdowns. Tell us in the comments, who do you think is at fault? The system, the defendant, or both? Would you have done the same as the judge? Your take could spark the next episode.